Welcome to All Things Social Security. My name is Stephanie Joy of Joy Disability. I am a Social Security disability attorney, and I would like to invite you to watch our daily video tips on the Social Security Disability and SSI claims process each day at the new time of noon Eastern Standard Time here on YouTube on this channel. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A live stream. So you are welcome to join that as well. Ask your questions, get there on time, and you'll be one of the first answered. Thanks so much and have a great day. Enjoy the video. Hey guys, hope you are all well. Hi Christina, I see you're number first. Hi Kevin Johnson. Hi Dimple, good to see you guys. Okay, so here we are, another Wednesday going down. So before we get started, and I see one question there from Dimple. I'll be there in a second, Dimple. Let me know if you can't hear me. Hi, George. I just wanted to give you a quick going forward things that'll be coming up on the daily 12 o'clock video shares. I think on July 26th. These could get altered a bit, but real soon. We talk about VA TDIU and when it is not always a sure thing with SSDI, despite the finding by the VA of unemployability. Also upcoming, this should all be next week, guys, is just a little share explaining the difference between the legislative process, which affected some recent legislation that was all that huge hullabaloo between regular order versus reconciliation, and why some things are the way they are when it comes to that, the reasons why they do it, and the limitations of it. And then we also have a discussion about those that want to get their SSA file after they've already gotten an award, because they just want to have it, which I don't think is a terrible idea, because it can also help you with a CDR later. That's coming up. And also soon to be, and this should all be still in July, we kind of talk about, and I haven't finished getting the reference for it, which I promised, I think, in the video, getting an older grade application with an age change category, even though you haven't hit your birthday yet. So we talk about that because there are rules on that when that can be allowed. And that's really all I got right now. So anyway, let me go back to seeing my StreamYard. Okay, so if you have questions, guys, put them up. I see Dimple says she's in the process of being discharged from the hospital, and hopefully she'll catch me a little later. So you're popping in to say hi. I appreciate that, Dimple. Yeah, sometimes those discharges can take forever, right? I remember when I think kids of mine were in the hospital, and it would take like 5 hours before they'd get around to doing the paperwork to get you discharged after you were already fine and ready to go. It was really, really annoying. Anybody else? I'm not seeing questions, guys. I'm just seeing a bunch of hellos. What's going on? Bring them on. Or what shall we talk about? Does anybody have any questions on function report issues, work history parameters? I mean, those work history reports are so important when we are, it's always important, but not nearly so much as when you're 50 or older. And I would say then also when you're, say, 49, because you might, if your case slides sideways, 48, 49, but you're going to have room for another case to retry it. You kind of want the work history report, the way you described your work at 48 and 49, to be as accurate, because it could actually come up and bite you in the butt later if you later on do it more accurately. That could help you prevail. But meanwhile, back here, you said something totally different in terms of exertional, or you never mentioned you lifted that much back then. So what's going on? So those are kind of things you can focus on. Anybody have questions? I really appreciate saying hello, guys, but this is really supposed to be a Q&A. Right? So usually you guys already have like 5 million. I'll say hello, Kevin Johnson. Nice to see you. I don't think I mentioned that before, but in case I didn't. I'm trying to think of what else I could share with you off the cuff, guys. Well, if we're going to go into just fun facts, the ordering your SSA file when you have already prevailed, they might try to charge you, and they probably can get away with it. Be careful about the price, though. I've heard a variety of prices being demanded by a staffer. And, you don't really need that. So I've heard up to $120. I think it was $123 for some reason. But then normally, like other times, I had heard that they are only allowed to charge 10. And that might even be in writing someplace. I'm not sure. Hi, Kevin. Kevin's still waiting for his ALJ hearing. Are you still treating really heavily, really kind of going balls to the wall before that hearing? Because that's the kind of evidence that can be there. Be coming into your case last minute. They didn't have it on recon. So it's definitely new. Sometimes that newer evidence while we're waiting for while we're waiting for our ALJ hearing, is the stuff that can actually give the ALJ reason to overturn a denial without having to, if there's any pressure from above, and I'm not saying there is or is not, but if there's any pressure of above to give due respect to adjudicators on initial and denial, new evidence is the best way to allow an ALJ to, if he feels the need to save face, to flip it and save face. Maybe with a subsequent onset date, potentially, but maybe not. I mean, we get a lot of them flipped with the original onset date alleged that the initial or recon people did not quite see it the same way. Now, sometimes that's because they didn't get all of the evidence. And if everybody's struggling to get a certain medical provider to provide evidence, or the client has had longstanding complaints of, say, pain in a certain area, but didn't have a diagnostic because the insurance company wouldn't approve an MRI, they had to go through PT first and all this other silliness, then sometimes that's what comes up later. But it helps, it gives the affirmative diagnosis, but sometimes the judge will go back nonetheless to before that because all the complaints were there, the long-term treatment was there, maybe falls were there, other evidence of it being really severe, not just the MRI that came later, which is the more objective proof. So Beth says, I'm working on work history report now, but struggling to define the managerial part when traveling, working with. I would not go in the weeds on that, Beth. And we'll talk about this later, of course. But the more brainiac you are in that, and it's going to be clear you're brainiac. It sure is. But I see some people put like all the different code languages they had to work with. It's like SSA doesn't care about that. You're already in the skilled area. So one thing I will say also about managerial, if you're managing other people, like supervising, some people make the mistake, in my opinion, of saying they 100% of their day is supervising when they are actually hands-on doing work, not just supervising from the ivory tower. They happen to be a supervisor because seniority-wise, that's where they lie. And they may have, they can delegate things or what have you. But that might be 10% of their day. 10% of the day is actually acting as a supervisor versus just holding the position and having always, of course, the chit runs uphill. So be careful, make it clear if you're actually a working person while you're a manager. You're still doing a particular job with clients, for instance, and you don't manage clients, you manage subordinates, other employees. So keep that differentiated too. We could definitely, I do know what you're saying though, Beth. It is hard, but I do see people focus. It's like they're trying to sell themselves like a resume on their work history report. And I'm like, man, you're not trying to show how great you are. You're just not. You're going to give the basics of what you did. Don't go so into detail that you're talking about, I don't even know what the new code languages are, but I'll see people go, we use this software, that software. I'm like, that is too in the weeds and that's too micro. Nobody cares about that. That would be important if you were applying for a job that wanted that skill with that particular software. But that's not for this. They're trying to get at more about that you are high skilled, which that's going to be no doubt. And that's hurtful to a case, but not indefeatable if you have reasons why those high work skills could not then transfer to something less exertional. Because remember, depending on your age, you have to, in order to get the grids to apply it all, you have to really hone in on your physical impairments, and you have to get your physical RFC that they're going to decide. You have to convince them that you are either limited to light work or less, or sedentary or less, depending on your age, right? 54 and under, sedentary and less. 55 and older, you can be as high as light and less and still prevail. But you have to also be able to prove that you cannot transfer those skills from that brainiac job to one of those sit-down jobs that were not so arduous. Which also brings me to the point that on the work history report, you want to draw out every exertional thing you did. If you're on your feet, walking a lot, traveling is very on your feet a lot. So I would be definitely for sure mentioning that. If you're darting between clients and meetings and you're on your feet a lot, you might sit when you get there, but you're doing a lot of running around. That will go towards hopefully getting you out of a purely sedentary managerial job, which is going to be hard to defeat unless you have significant mental health issues, because then you can't necessarily transfer those skills to another job because something would impede you from succeeding at that or using those skills again, something that didn't exist then. But yeah, you want to point out, like if your job was also like, yeah, I'm a manager, but sometimes I got to go in that stock room and grab a box of reams of paper because we have like 4 printers and they got to get out there. So whoever's available does that. A box of reams of paper. I think it could be like 8 or 10 reams in there. Even if it's 8 reams at $5 a pound, that's a 40-pound lift. That automatically takes you as your job. And it might only have been once a week, or maybe even less, but I would mention it. Sometimes I had to go get that box of paper. You know, it could be twice a month, it could be once a month, here and there, you know, kind of sporadic, but when it had to be done, it had to be done. And so to do that, you had to be able to lift 40 pounds. Capish? Or if you have to fill the printer and you have to crouch down and bend, something that you can't do now because since then you've had more severe back problems. So you really want to hone in on the exertional things you had to do, right? It's so important because one of the three things in your grid, three-pronged process, is proving that you cannot do, well, if you're 55 and older, can't do more than light work. So you can't lift that 40 pounds anymore. And that job was a 40-pound job because one of your prongs is I have to prove I couldn't do that old job, plus that I'm stuck to light or sedentary, depending on the age group. Okay. All right. Good to see you guys popped them in there. God, you guys are so shy. It's so unusual. Usually there's a ton of them beforehand. Okay. Steve Henderson, nice to see you. Steve says, on initial approval, is it true that there is no 5-year diary date, only 7-year? Only talking about the 5 to 7 year slot? No, I think it is a 5 to 7 year slot. I think when times are tight and things are backlogged, a 5-year, they're not really falling behind if it ends up in 6-year or 7-year because it's a 5 to 7. It also, however, gives them the opportunity to do it at 5. Let's say there is a major medical development in medical technology and, you know, the medical profession industry, and treatments are happening that would literally alleviate a lot of limitations in some people with a particular impairment. They might want to opt for the 5-year on that because, you know, see if the person had it. Are they doing better? Because most people don't step up and say it. Not because they're dishonest, but because I think that nobody knows if a brief improvement is going to be lasting. So you're improved for 8 months. I've seen people improve for 8 months and then slide right back down. Deterioration happens. It could be from aging. It could be from an aggravation to the existing impairment, you know, because we wax and we wane with a lot of these medical problems. So I would say it could be a 5-year. I just think that because we're always so backlogged, that's probably why you're seeing more of in the practical world a 7-year. So it's to everybody's benefit, so we won't complain, right? For a 7-year over 5-year. AITCH, how do you pronounce that? H? It looks like an H in your picture. I don't know. Thank you for all your videos. Thank you for being here. I appreciate it. Kevin Johnson says healthcare insurance is going to be tough to get. ACA just rise their price. Yeah, well, they did that to us back when I was on that every year and then diminished the coverage. So I'm not a huge fan. I understand it's a necessary evil. It's better than nothing, right? Yeah, Beth, sometimes don't overthink it, but don't leave out those things. So sometimes you have to think about things you might not normally think about. When we think about our high-end managerial, our high-skilled brainiac jobs, we're always thinking about what's going on up here. And we don't, like, for instance, let's say I was to do a work history report, lawyer. Well, that's just like brainiac work. You don't lift a finger, right? No, I pulled out a green screen today. I don't know how much that weighs. It's got to be at least 30 pounds, maybe. I don't know. And it's very big and cumbersome. That would take me out of light work because light work extends up to 20 pounds. You see, that would get me up into medium work. And I do that every week, by and large. Sometimes more frequently if I'm screwing around with something. I lift my Vari desk up. I lift monitors. You know what I mean? I don't really do a lot with big boxes of, the last time I bought a big box of paper was probably 5 years ago, and I'm still using it because I don't do a lot of printing. That's kind of out of our chosen way of doing things. So I have paper. I do need it sometimes. I have a printer, I have a scanner, laser printer, blah, blah, blah. But I don't do a lot of that. So I probably wouldn't be putting on lifting a box of reams of paper, but as a lawyer who is not in a big firm where you just sit at your desk and do research all day for the big firm, and most of us that have our own practices do a lot of running around, a lot of driving. If we're going to go do certain things elsewhere in terms of networking or holding events or things of that nature, sometimes bringing paperwork to a homeless person that we're helping. So there's all that. And then just outward meetings and networking and all that business. Ulysses Lewis. Hey, Ulysses. I'm a Lewis too by marriage. My maiden name is Joy, but I'm a Lewis by marriage. Hello, just wondering why I was approved without ever having a CE and my CDR is set for 2030. Good. I was approved in 2023 and I was almost 62 at the time of approval. Okay, so awesome. I suspect you're not going to have a CDR at all, Ulysses. And you didn't need a C. The only reason they do CEs, guys, is because your own medical evidence is not ironclad. And sometimes a CE, not often, but sometimes it will put it over the edge. A lot of times they'll have a CE because they want to just make sure that what they think they're seeing is so. And then, of course, a lot of times the CE is because I think they're compelled in some way, shape, or form to acknowledge that, well, there is a remote chance that that weak evidence could mean disabled, so that nobody screams that we didn't help. We're going to offer a CE at our expense, and then we'll deny if the CE doesn't say something vastly different. Or sometimes they'll deny and they'll say the CE was an an underestimation of limitations, underestimation of capacities and an overestimation of limitations. So it is, but that means that your evidence was very good, Ulysses. So power to you. And at 62 and 23, or now 64, I'm not seeing a CDR for you at all, which means a medical CDR. So don't screw it up by, going out and working full time and earning, above SGA. Hello, Maggie says, hi, any tips for the mental and medical consultative exams? They finally sent me those exam dates. I do have a few videos on that, Maggie. So I would direct you to those. The biggest take home, I'd say, that would apply to both. Don't be Superwoman. If you're so used to, which I'm telling you, 99% of my clients always are, they're just been hardworking people most of their lives. There is exceptions when it comes to some folks that never did work much for a variety of reasons, not necessarily because they were lazy. Some just stayed home and didn't, that was their culture or whatever, maybe raising kids, and then they stayed home even after the kids were on their way to full-time school. But most everybody has been hardworking, and they really covered up their growing problems and kept their jobs as long as possible. And they're used to not complaining. They're used to not seeing providers as much as they should for the purpose of evidence development. I'm not judging anybody's medical choices. And when they go to consultative exams, I know sometimes people, they're in that habit of saying, yeah, everything's okay. Yeah, I'm okay. Well, then why are you filing? Well, I've had some back issues, like really vague. That's not good. So you really want to not be Superman or Superwoman. If you walk with a gimp, with a limp, don't pretend you don't have it when you walk into that office. Don't be Superman or Superwoman, and be very frank about all of your ongoing complaints. That is the biggest thing I can recommend. I see it often. Well, my clients, they've already seen the video guidance, and so they presumably don't do this. And I see the reports later, and I think they're doing pretty good. It's usually when I look at their medical records with their treating doctors, you have like this relationship where you constantly have this nice, friendly little thing, and a lot of people just don't open up. Sometimes they're like, my doctor's very happy that I'm doing so well. I want to be like, your doctor really doesn't, no offense to the doctors, but they're happy for you, but it's not like, it doesn't affect their life one way or the other. So don't try to please them by saying how great you're doing. If you're thinking, well, it makes them feel good because they're doing a good job with me, don't even worry about that. You just got to be frank. You got to show your complaints. If you need to, bring a list, because you're going to forget. It's so easy to forget on the spot. You're nervous. Then bring a list, a little outline, like these are the things that, here's my list of everything that bothers me every week. It's not like once in a blue moon, and how they limit you. And he will have to note in his report that he was provided this by you. So if he kind of denies it later, that could be a problem for him, not for you. Brian Kivel says, hi, Brian. I don't think we've met. I have an ALJ hearing in October. And if we have, I apologize. I try to memorize a lot of the names, but I'm not always perfect. My assigned judge is a 33% approval rate. I feel pressured to have my ducks in a row. Everybody should feel pressured to have their ducks in a row. Even if he had a 65% rate, Brian, because a third of those people get denied because their ducks were not in a row. Do you have any suggestions for preparation? Well, it depends. Preparation for hearing, I can't say specifically because I don't know your case and what you should be talking about. But for sure, if you do not have, I don't know what your problems are. Let's say they're physical. If they're mental, that's going to be a much, much harder thing, because it's really going to depend on what your treating providers how they've described you in your mental health records. Do they always say doing well within normal limits? Therapy's great. I should continue, but therapy's working great. And all those little MSE, mental status exam questions about affect and mood and appearance and speech patterns and reactions are all within normal limits, WNL, then you're going to have a tough time if it's a mental health case. But if it's physical, there's things you can do. If you haven't been, I assume you've been going to all your specialists, right? If you have a back problem, you're going to a back specialist, not just your PCP. Diagnostics, you kind of want them updated ideally within the last year. So MRIs in particular, x-rays pretty much don't show diddly, although they can be helpful if we are at an age where we don't need to show that we can't even do sedentary work, or we certainly can only do sedentary work. If we're at an age where that extreme physical limitation isn't required because of the grid rules, but we just have to show we can't do medium work, x-rays might work if they're showing a lot of severe like arthritic stuff, bone spurs, all this kind of stuff. That might be helpful. If you have carpal tunnel, did you have an EMG? I mean, it really depends on what you're coming from to know what you've left undone. You want everything to be top notch and like you really, really took your treatment seriously, because that shows that you really, really take your impairments seriously, because they are extremely limiting on the quality of your life. You know, you're not working at work now, right? So presumably, if you are, it's only part-time. And if we're having significant limitations and pain when we don't even have to work, well, we're not able to work. So we're at home where we can go lie down whenever we want. And we're still having major complaints and treating for them because now we have the time. You know, we can't say can't go there because I'm working, which is always my excuse, right? That can be significant. And I would always drive that home. Like, while my client is not even working, these impairments are getting worse and more limiting than they were. So it all depends on the case, Brian. If you have an attorney, of course, he would be advising you on this. And if he hasn't, just ask him. Or a non-attorney rep. Don't want to leave out my non-attorney rep colleagues, who there's many a good one out there. GC24 Styles, good to see you. I think we've met before. If a claimant suffers from a chronic condition that's stable, like stage 4 renal disease, how does that affect the claimant's outcome? Well, if they don't meet a listing and they have no limitations on doing, let's say, sedentary work or light work, and those are the kind of jobs that would sink his case, then that could be a problem. So it really depends on, where your evidence is at with that. Do you meet a listing? If not, you have to show. I mean, a lot of people have renal disease and they could still work. So why wouldn't you be able to? You have to show that. And again, depending on your vocational profile, prior work you did in the last 5 years, as well as your age, mostly, it's usually not education, that is going to affect which rules you have to try to get your evidence to meet. It's not the same for everybody. I'm glad you liked the video. I appreciate that. Thank you. Kitty says, hi, and thank you for helping so much. That is my privilege. Thank you, Kitty, for being here. I appreciate you. I appreciate you. I'm worried about the form. I've heard I have 10 days to return if my CDR comes back as denied. What form is that to continue benefits? Really, I think you can be in the form of a letter. There is a form. I just don't know the number off the top of my head. I don't really have clients that come back to me with CDRs that are denied, so I don't really touch on it that much in that regard. But I do believe if you do a letter and you title it, request to continue benefits pending CDR appeal, that's notice. And when you get it in, this is tricky because of that 10 days, which I think is extremely unreasonable, because we often don't get it till like day 11 and then the time has passed. I would document what day you get it. I would overnight have the letter prepared. Just have it prepared. Hopefully you won't get, your CDR will not come back as denied, but have the letter prepared. You can fax it in and keep your confirmation to your field office. In theory, you can go there. I would prefer you didn't. I'd prefer you get someone else to go there with 2 copies, file the one with them and say, I want this stamped as received so I can bring it back to my file and show what day I filed this. Or, more expensive, overnight it. And if you overnight it, I would fax it too, because gosh forbid the Postal Service doesn't overnight it. In fact, out where I am, they even tell us, well, we can't overnight that from here. So everything is going to be 2 or 3 days. That's the earliest. There's got to be other ways to do it. If you had to go into your field office, but again, are they even letting you in? I don't know. Does there have to be an appointment? I don't know. Fax is always a great option because you have that proof that you're going to keep. So if they ever say you didn't notify us, yes, I did. Here's my fax confirmation that you received it. The only reason I say don't rely only on fax, because I always get concerned if someone's going to say, well, we didn't actually receive it and that fax confirmation is faulty, that text service you use or whatever. I haven't had that experience yet. They allow it because you obviously tried to notify them and your notice it. So I haven't seen that ever be knocked down, but it does concern me because you just never know where, So I have always tried to do both. Like when we do appeals, I have my appeal and I have my online confirmation. I just did one this morning and that gets saved and every little piece gets saved. And then I also fax a letter to the field office saying appeal has been filed. And in this case, because I was just coming on board for this newly denied person to file recon, I had to send in my representational documents, 1696, 1693, and I also sent in their 827, but I also uploaded that stuff to the as attachments to the appeal when I appealed online. So I kind of hit it up from all angles. I don't know. Better to be thorough than regretful, right? But that's what I would do, Kitty. And I know that's such a short time. Sarah Joy, love the name. But of course, how do you interview for a job so you don't make over the I can't tell you how to interview. I am not an interview expert. I haven't interviewed in 30 years, probably maybe more. Don't make over SGA without disclosing you're on disability. Just vaguely say, no, I can't make. No. You're going to apply for jobs. You can apply to all and not take the job, first of all. Just because you get offered it doesn't mean they are your dictator. You don't have to take the job. But look for jobs that are asking for part-time. And when you interview, to say, if you know a job pays $15 an hour, say, do the math. You know how much you can work. Stay well below the 1620. Don't flirt with it. Because, just don't flirt with it. Say you don't go above 14 or 1500 tops. Do the math. Figure out how many hours it is at $15 an hour. And then when you're there, it might be hard to figure out the math in your head if they give you a number that's over what you can do. But you could say, or they say, well, we pay $20 an hour, because that is going to affect how many hours you can do. So that's just something you have to do your own math and get your little cheat sheet out. And you don't normally have to accept the job on the spot. So you can always say, yeah, thanks. I'm definitely going to think about this and talk to my family or whatever, and blah, blah, blah. Go for the part-time jobs, of course. You can also try going to a county level vocational rehab, or it could be like another kind of outfit, maybe an NGO that lines up employers that are actually looking for disabled employees. Like maybe there's a tax benefit and they want the disabled employee who can do a job for a short period of time, at a reduced rate, because they're not as fast or as able as somebody else possibly. And they will usually understand that constraint. So that's just another place to look, instead of going to, because you probably heard my other things, Sarah. You don't have to, if you say you're on disability and it's an employer that is like, well, she's clearly saying she can't do the job with or without accommodation, so I'm not hiring her. I don't know. I just don't necessarily, unless it's an employer that is looking or compassionately or for a tax break in the business of hiring disabled people that are on SSD or applying. And there are out there. You just have to find them. So that's why I suggest going through an organization that is geared towards that. And then you can be as open as you want. Another thing some people do, Sarah, is gigger work. And that would be, you could be babysitting dogs in your neighborhood. I could go and house sit for 3 hours when someone's like, I just need someone to watch my dog while I'm gone, or whatever, Not necessarily walking them, because that could be too physically arduous. It could be house sitting. It could be the kind of gigger job where you actually get a 1099 because the person you're doing it for is a big company, such as DoorDash or Lyft or Uber driving. I'm sure there's other ones out there that I'm not thinking about. I know there are outfits that do, and I know because I used to do it when I used to be a gypsy, doing many different moonlighting jobs when I first started my practice in Jersey before SSD. So this is like 25 years ago. And I would do this high-end babysitting for rich people. I lived in a town I grew up in. We were not rich. We were like farmy people, but there was this is in Jersey, very wealthy towns, including the town I grew up in, ended up being quite wealthy. That's why I had to hightail it. It would be like, and this is like 25 years ago, like $13 an hour at night while the wealthy people went out to their fancy stuff. They were very nice, beautiful mansions. I mean, and you just go be the adult in the room while the kids were sleeping. It was amazing because I would make the money I needed to pay my rents. This is before I was married. And I got a 1099. And it was easy. I actually could study too. And in fact, I don't think I was studying SSD yet. This is before that ever became a twinkle in my eye. I didn't even know about it. But I would study other things because I had a general practice that I was trying to build up. And it was before I did a 180 with Social Security disability. I was very, very young and energetic. And it was a great way to make money with very sedentary, you could talk to the people about, and this was a company that it was just great. You weren't housekeeping in any way. You were literally the adult at the house, so they could go out and their 10-year-old sleeping upstairs or their 3-year-old, you check on the baby. That's it. It was super easy, but you have to be responsible. That's all. So that's another idea. All right. Hi, Maeve. Good to see you. Sitting all day is a whole other problem. Yep. Sedentary work can still be. Absolutely. I developed some problems from my extremely sedentary days, Maeve. When even having a meeting across campus in your large company means you're walking a distance in a hurry. Absolutely. And those, Maeve, are the type of things, those walking far to get to meetings need to be in that work history report we were just talking about before. Because if you have to walk through a complex and maybe you're walking a quarter of a mile, half a mile every day, because that's part of your job to get from meeting to meeting, I would definitely put that in there. And so when you're thinking, when some people are thinking it's an 8-hour day sit down job, it's not. You might have an hour on your feet. And then think about all the other walking in a sedentary job. That might actually, without that, they usually assume that a sedentary job still requires you to get up 1 to 2 hours a day. It's still considered sedentary if you do that. But if you can tip it over legitimately into 3 hours, now we're talking a little bit different. So definitely take all those things into consideration. And traveling, people that travel for a sedentary job, otherwise, that can be very arduous too. So I would include it all. And what I was going to say, Maeve, also, the problem from a practical point of view when convincing on a case, they reduce people in exertional and they get them down to sedentary. To prove that someone can't sit all day is something that I've said this before, something that the SSA is loath to do. They tend to want to put everyone at sedentary. And really, when someone can't sit sedentary that long, or they can do it a half hour, but then they have to switch up, and in the end, it ends up being 4 hours of sedentary and 4 hours of up and down or whatever. They're loath to say the person is unable, even if they have a horrible back situation, unable to do, or hips, unable to do sedentary work at least 6 hours or 8 hours. It is so rare to find them say less than sedentary. I've seen it, it's happened, but it's so rare. We have to just go to rely on that would be putting a fork in the case for 99% of people that could otherwise win if they just did what they had to do with the rest of it. I don't know why that is. And it's definitely true. Some people cannot sit 6 out of 8 hours, but they're going to be held to sedentary 99% of the time. I'm saying 99% of the time, guys, because I'm not actually counting, but that is my off the cuff estimate of indicating that's a very, very high amount. Trish Wade, hello. Good to see you, Trish. Long time no see. Second phone. My lawyer received source statements from 2 of my doctors that support my claim, plus lots of proof of limitations and issues in medical records. I have high-level education and under 50. I think you're saying, will I be approved? I don't know. I know you have a higher burden of proof than 50 or older. Second phone. So it really depends on the impairments. I mean, we do win the under 50s. There's honestly, I feel like because under 50 is such a broad age range, we've got 18 to 49. There's far more people claiming disability and who have really severe impairments and are claiming disability far more in numbers than we have probably 50 and older, even though we get more decrepit as we age, as I can attest to. We win those, and my colleagues win those when the goods are there. And if your doctor's opinion forms on your limitations are really, really self-evident in their treating records as well, that is obviously the most important thing. And then you could prevail. I really want to know what happens. So if you can remember to come follow back with us when you get your result, if you prevail, it would be a good thing for maybe other people to hear, because a lot of people rightfully know that under 50 is extremely, extremely hard, and most people don't prevail, but then the ones that have the goods do. So it might be a little motivating factor for people who might otherwise give up. Alrighty. Glamour girl, long time no see for you. How is it that there are doctors' medical opinions in an ALJ denial that the claimant never even saw or heard of? Okay, that's because it depends what it is. If it's a mistaken doctor report in your file, you need to look at your file and make sure they don't have someone else's records in there. That wouldn't be the first time that's happened. But usually it's the medical expert who reviews your records and then determines at the initial and recon what the RFC is, what those records say your residual functional capacity to do work-related tasks is. So he gathers all that, all that information is presented to him by the adjudicator for him to come up with this medical RFC, and you would not have met him. That's purely based on the medical records of the doctors you did meet. So that might be what you're seeing. I can't say because I don't see it, but that could be. But you do want to look and make sure if you have your file. Well, I'm sure you've done this. Check to see, are they talking about me, this doctor? Does it say I visited her on so-and-so? Or is it a documents examining doctor who's taking all the medical records from all your doctors and putting together what their records indicate you can do and not do? Both. LC's in the house. Do all the claimants who get awarded SSDI get CDR? How is diary day calculated? Okay, so by and large, yes. However, for practical reasons, sometimes there's never going to be a CDR because they become 67 and there's no you're not on SSD anymore. So if you win at 62 and you have a 7-year diary, you're going to be 69. You're not even on Social Security disability anymore. You're on retirement. For reasons like that, there would not be a CDR. But yes, everyone who gets awarded an SSDI claim or SSI should be getting a CDR at some point. Usually they have that diaried, I think, when you prevail. You might not see it in the letter, but you can call and ask what it is. And the diary day is calculated on the nature of your particular conditions and your particular treatment, and whether that everything else about you, could be your age, etc., and whether you're expected to improve or not enough to go back to work. Medical improvement expected, MIE, that could be like a 1-year CDR, could be 18 months, could be 6 months, could be 3 years. There's medical improvement not expected. That tends to be the 5 to 7, the longer time frame. And that, I think, will also depend on your age, because if you are going to be changing an age category, because that will be used to your benefit on a CDR, I think they look at that too. So all those things kind of come together in some weedy fashion, and that's how they come up with the diary. Okay. Wayne Corder, hi. Have a great day, you too. Love your flag. Lulu says, nice to see you, Lulu. I got a partial approval. My attorney wanted me to appeal my onset date. I told her I do not want to appeal because I want to put this behind me. They already pay my attorney, now what? You do not have to appeal. And appeals are risky. They have the risks. Not always a notable risk, but, and aside from the fact that, yeah, you're saying you want to move on, you're satisfied. It's always really, I suppose I should say, it's always up to my client whether they want to appeal. I always give them the risk, the riot act of the risk. And particularly if they are under 55, sometimes I'm like, you might just want to take a bird in the hand instead of grabbing the other one in the bush, because all you need is, I don't know. It's never happened to me when I appealed that my person, anything was reversed, but I've heard it happening to people. And there are some that I would say, yeah, I would appeal this. It seems like they ignored this, this, and this. But, that means you drag on for another couple of years usually. So I could definitely see wanting to move on. If you didn't get back benefits, and I've had that where people are approved, but there's no back benefits. I get no fee, only because I generally choose not to file a fee petition. And I don't want them having a bill after the fact. I want them to leave the relationship loving me and feeling good about the whole thing. So I kind of chalk up those. Usually, if they're a super wealthy person, totally different, because yes, you can pay your bill. But for everybody else who would have a bill that, it tends to go where I waive, pardon me, I'm wiggling around here because of that sedentary job we're talking about. I tend to probably 90% of the time waive it. And yeah, they would have paid the attorney if you appealed it and then you got more back benefits. If the attorney hadn't hit the cap yet, they'd get a bigger fee. So that would come after. When you get your more, they'd get their more. But yeah, I totally get what to call it a day. And it's up to you. I presume they did not file the appeal without your permission, right? That would be very inappropriate. And if they did, and I don't think they did, but if they did, you can withdraw that appeal. And I would do it ASAP. Sarah Joy says, not legal advice. If you are deemed disabled and the job you are currently at contributed majorly to it, would it be wise to seek legal advice? I'm not really sure about the first 3 words that you're saying in the beginning, but if you are deemed disabled and the job you are currently at contributed majorly to it, would it be wise to seek legal advice? Well, technically, if you become disabled or more limited in work, that's technically a workers' comp case, I'm going to say generally, Sarah Joy. However, if you decide to put workers' comp into if you're otherwise trying for SSD, you might really regret it. Workers' comp generally takes control of any treatment decisions, and you no longer have choices for a certain period of time anyway. Every state's a little different. It goes by state, and then if you're a lower income worker, not a high income worker, if you get workers' comp, it's probably going to be taken away from your SSD, or if you win SSD, it's going to be taken away from your workers' comp because you have an 80% rule that you can't supersede when you collect both of those benefits that are attributed to the same months. So be careful what you wish for. Sometimes it's better if it is really a degenerative thing that was happening anyway, and it was going to degenerate anyway, and you're like, well, I have to be on the job, therefore. It's not necessarily a great idea or a legal requirement that you would try your hardest to get that jammed down workers' comp's throat, because you may indeed pay the price and walk away with nothing more for it, assuming you win both cases. So all that work and hassle and limitations on how you can treat because of the workers' comp. Just something to think about. Mental health disability claim. Yeah, you're probably not going to win that on a workers' comp. And I'm not a workers' comp attorney. I just hear the scuttlebutt. So you'll do your own due diligence on that. But proving that it rose out of that work in particular is going to be very hard to prove, I think, in a workers' comp case. So you might be asking for a battle for the next 5 years with nothing to show for it, except now you can't treat. And then your Social Security case goes down the drain too. So you got to be super, super careful. If you're not, if you think about it, and you guys probably all have opinions on this, mental stress from work. And it's not to say it's impossible to win a workers' comp case, but if we are mentally fragile to a certain degree, whereas other people aren't hurt by the exact same stress, it might very well be something that they really are going to fight you tooth and nail on. And you have a big battle, meaning workers' comp, because you have to prove that nexus. Not just that you happen to be working at the time, there has to be a pretty strong nexus, arose out of and in the course of employment. But if you are already mentally fragile with conditions or disorders, that might not fly due to the pre-existing nature of that. So it's a tough one. But from my perspective, and from a very SSD-centric perspective, I have a lot of workers' comp cases. I don't like that aspect of them. I prefer the people who weren't doing workers' comp or getting workers' comp, because it throws a whole monkey wrench in their case usually. So, and then sometimes they work as comp attorney and they're trying to jam everything in. They have arthritis, now they want that in there. They have psoriasis, now they want to throw that in there because they heard on the internet that it could be caused by. And I'm like, don't. Now you can't go to your own psoriatic arthritis doctor. Now you have to go with them, and they're going to be like slow walking you through treatment for the next 3 years. I'm like, don't try to stick everything in there. You're not going to get more money. Buy a couple more cents if you were to prevail on it. But in the meantime, you can even kill your entire Social Security disability case, which then means you decimate your Social Security retirement for later, because now you can't prevail on your SSD case because you let workers' comp control your life in that way with treatment. And again, every state is a little different. Some are more, shall we say, pro-employer than others. But I always say, in my opinion, workers' comp is generally made for the employer's benefit, not the employee. It can be very great if you're not disabled, if you just have a temporary injury. Awesome. My husband hurt his knee at work, had to have surgery, boom, workers' comp. He only used workers' comp for maybe 2 weeks, but because then he got a different job anyway. But then it's cool because you go back to work. But for those that become disabled, workers' comp, it's not. I don't find it to be favorable. Maeve says, I got referral for PT. Only one here, rural. Okay. I love rural, Maeve. And he just offered no healing modalities. Wants you to exercise the shoulder that's swollen in pain. Cops an attitude that it won't because it hurts. That's one of two. 2 decades of pain. I have better tools than he does. Traction, TENS, ice, paying for massage is better than PT. Wow. So he's not even doing any manipulations or anything like that. Maeve, what? Wow. How far away is the next guy? And I can't believe it. That's horrible. Did he say he only wants to see you that one time and he's going to send you home with exercises, which means you're not getting PT? Just curious. Ryan says, I'm a first timer here. I knew I didn't meet you. Thank you for clarifying. I guess I should have been more specific. 51 with low, yeah, I can't read the mind, right, Kevin? Right, Brian? Brian Kivel. I'm 51 with low back. Okay, so times 4 at 47. Nerve problems when walking and sitting. Combat PTSD. Fibro. You're a veteran, Brian, as well. Fibromyalgia, seeking treatment for all. Good. You have to prove you can't do sedentary work. So you have to get onto that. I mean, the mental's not going to mentally put you out of all jobs in all likelihood, particularly if you don't need institutionalization. You're not so bad that you feel the need to get stabilized. Everything's copacetic. I almost knocked down my green screen. We're going around like this. I forget what your first question was, Brian. I could scroll up probably. Let's see. All right. So Brian originally said, I have an ALJ hearing in October. My assigned judge is a 33% approval rate. I feel pressured. Well, yeah. And like I said, you should feel pressured to have your ducks in a row. Do you have any suggestions for preparation? Are those diagnostics for that low back up to date? Do they show nerve impingement? That would be helpful. If they just show a herniation with no impingement, no compression of the cord, no moderate to severe spinal stenosis, could be a problem. Yeah. I mean, problems with walking and sitting, but you can do both for short periods of time. They might argue that you can have a job that does the alternating sitting where you can sit and stand whenever you want. Some factory jobs, for instance. Do you have any problems with your extremities, like nerve problems with your hands, radiculopathies down into your arms, numbness and tingling of your fingers? That would be with an EMG perhaps, or MRI showing radiculopathy. Combat PTSD, it sounds like you said you're treating for all that. Fibromyalgia, who are you treating with? Hopefully a rheumatologist that is fibro literate. Usually someone might prescribe even a PCP, might prescribe like a gabapentin type of thing. The medications, kind of speak to severity in one shape or form. My expressions are fleeing me. Brian, you are welcome for my time for sure. And thank you for your service. Yeah, I would, it's a hard one. 51 is better than 49, as you know, Brian, but it's still a major mountain, just not as major as 49. Because even you have to prove you can do no more than sedentary. Did I say that right before? No more than sedentary. So you have to prove you can't do light work. Prove that you can't do the walking. If lifting is limited to 10 or less, that's good. That's hard to come by though. And as the walking, if you have feet problems, do you have neuropathies in your feet with those nerve problems? Shooting pain down the legs? It's all going to be in that medical record stuff on a very frequent basis, not just a one-time snapshot of one of your visits where it's noted and not noted anyplace else. Those are all the things that I'd recommend. It's hard to do it at this late date. Where are we at? End of July and August, September. You've got less than 3 months probably, but what you can do, hopefully you can do it. If you have opportunity for physical therapy, and not the kind that Maeve just described. Maeve, that's horrible. Physical therapists that actually do their job and provide the physical therapy, they often, can't say it's 100%, but usually they provide very good documentation of the complaints that you have when you're doing it, when it starts to hurt. A lot of times they will say at session today, how you they might ask you, I guess, is how they come across the information. Complaints post last session. So how are you feeling after that session and the next day? All the things you can share with them, and it gets in the notes, and suddenly you have all these things that show that these activities in physical therapy, when done in a very controlled environment, are really painful, even though they might be necessary. So it helps. When range of motion is very limited, that's very helpful. Okay. If you have balance issues, if you're a fall risk, I don't know how bad off you are. Has anybody ever mentioned, even a friend, that you really should use a cane? You're a little stumbly, Brian. If so, don't just go out and buy a cane. Well, you can go out and buy a cane, but you want to get your doctor to prescribe you a cane. Because if it's not prescribed, as noted in the records, it's not medically necessary under certain SSA adjudicators and ALJs, even though it would stand to reason that if I'm losing my balance. So yeah, and you're welcome. Dreamers Club. Do ALJs have to go by the grid rules? Of course. Yes, they do. And so does the initial and recon people. Absolutely. Those are the rules. Maeve, your reference to traveling. Travel techs get stuck at a table in a conference room, craning their necks at little laptop to write code. No ergonomics, horrific. Yeah, I can only imagine. A lot of the people I've known in work and outside of work here that do a lot of IT setups, that's a lot of climbing under desks. Because they often do not just the software part, but they often do a lot of the physical setup. Sometimes it's lifting things and moving them and moving things around and crawling on their knees to hook things up. That's a high brainiac skill, but it's also a very physical thing to do too. A lot of jobs are like that. And I always just drill it home for the high skilled job people. You need to hone in on all the physical things you did. Really, really think long and hard about Even if it wasn't something you did every day, but you only did every week, get it in there. It was required of the job. Dreamers Club, again, says, if my pulmonologist and psychiatrist both put very strict limits, less than sedentary. Well, if they say less than sedentary, that's not going to work because there'll be no reason why the SSA should believe that they even know what that means in the SSA world. On my medical source statements, what's the judge going by that if my records reflect it too? If your pulmonologist says, I don't want you on your feet using up your oxygen, I suppose, more than a couple hours a day, you need to really, I can't even imagine this, but because I think usually they say you should do some cardio, but now the psychiatrist saying you should remain less than sedentary, that I would need to hear more. That's the first I've ever heard that, because most of the mental health people are like, get some exercise. It's good for your psyche. So really less than sedentary, pulmonologist, maybe. Usually it's, do you have any other physical problems, Dreamers Club? I don't know how old you are, but like, how about that back? How about your joints and stuff? Do you have any issues with those? So I don't know. But if there was, as you were asking overall, medical records describing how bad being on your feet more than a few hours a day would be, and why, which diagnosis would that hurt? Can't imagine it's pulmonary. Can't imagine it's psych. So I'm not really getting that, but I don't see your record. So there's obviously something I don't know about. Yeah, that'll certainly help if it's not ludicrous. Pulmonology, I mean, if you're like on oxygen, maybe that's it. Are you on oxygen like 24/7? I believe that could very well stick someone to sedentary. Now you want to be less than sedentary, it looks like. So I'm thinking you're under 50. That's going to be tough because sedentary is sitting, and that's where most people are doing their oxygen. John Kalamas. Hi, John. Regarding AOD, that's alleged onset date, guys. That's the one that you put forth as, I've been disabled since then. Please take my claim, and I want to prove it. July and August 2023. I didn't have income September 2023. I didn't have income. September 23 to April 24, I worked part-time and I was over SGA during the 8-month work period. Were you over SGA all months in the 8-month work period? And were you an employee, John, or were you self-employed? Were there any IRWs, impairment-related work expenses, you could deduct that would put you under SGA, and that would go on a monthly basis? If not, is it possible to use July 3rd as AOD? No, because you were not disabled from September to April. It wasn't a failed work attempt because it's over 6 months. So I would say generally that would likely be a no. You would have to use April of 2024 unless you have those impairment-related work expenses. You got to map and math out, ATH, out these things if you have them. If you're self-employed, although it's a lot more complicated, there is business expenses that can be written off because it's going to be your revenue that you are paid for your self-employment on your 1099 or otherwise, if you don't have a 1099 but you still earn the money. And then you subtract everything that you could write off with the IRS, and that could get you below SGA. Because a lot of people just put their gross down. They don't, on their Schedule C for self-employed, and they don't subtract out those things, or they don't subtract out many of them. And while sometimes that's good because you want to earn credits, if you're already saying you're disabled, then that you don't necessarily want to try to take the IRS for every business expense you can. I mean, there's no rule that says you have to write off every business expense you can. IRS likes more taxes, not less. Just saying. Marcus Wallace. Do you know anything on the approval rating in Kentucky for SSI? I saw it online as like 30%. There is no such, well, that's not true. Is that actually a real chance or a bad thing? It depends what you're talking about. I mean, generally speaking, most cases, SSDI or SSI, overall 30-something% win on initial. So that would be SSI or SSDI. So it doesn't really matter. It's the same finding of disabled or not disabled. And then, of course, say, and these are the numbers from a few years ago, but let's say 15% of those denied after the 30-something% prevail on initial. 15% of that next bunch get it flipped. And which, by the way, today or yesterday, we just got a recon award. So I'm really psyched. It took a long time, but we don't have to go to hearing. And where am I at? If it goes to ALJ, then another significant amount of what's left gets awarded at that stage. So it's not really related to your state, by the way, because it is federal. So you have to follow the federal law. So I would say it's generally not related to your state unless your state has a higher percentage of people who are not disabled fully from applying. That could be it could be where if their local other benefits offices, not really specifically related to it, say, hey, we need to see you apply for SSI and get denied before we can give you this. In which case you're going to have a bunch of people who are not disabled having to apply to get the denial so that they are then eligible for, it could be medically needy health insurance or stuff like that, sometimes for kids. So sometimes you have to apply even if you know you're not disabled under the rules to have the denial in hand to then go after the next thing. So it kind of skews things a little bit. You know what I mean, Marcus? George Graham with the praying mantis. Where will SSDI? And I'm curious why you pick a praying mantis, George. One day if you want to share. Did I ask you that before? That would be cool to know. I have a fondness for praying mantises. And it's not because the females bite the husband's heads off after they procreate. That's not why. I just think they're cool. And we used to have some when I was growing up. Where will SSDI be in 2032? When the SSA money dries up? I don't think they're going to let it dry up, George. Free Medicare to retire is free SNAP, free property taxes. Your insights, Stephanie. First of all, none of those things that were free that you're afraid of happening dry up the SSDI fund. So there is that. SSDI fund is totally separate. I don't know what they're going to do, George, and I don't really want to get into politics here, but I would expect, first of all, if we start getting a robust labor force like we had for years and years and years until people were encouraged not to work and stay in mom's basement, we will have much more money coming to the SSDI fund because 85 to 80 to 90% of what goes in there is from the current workers. So the more we want to decimate the workforce, the more we want to decimate Social Security. That would be disability and I guess retirement. But I also think, I don't know what they're going to do. I feel like most of us feel like if they're going to do something, don't start whacking people more off their working wages for more taxation to go into SSD because the people running the fund can't quite manage it. Rather, maybe they would be lifting the cap from the 180 something it is now, thousand that we get taxed on up to that amount each year of our income, and maybe bring that up to 400 or a million or whatever they want to do. I don't like increasing taxes on anybody. I'm not like an ist against wealthy people, at all. But the only thing I could say is if you have to do it, at least those people won't feel it, whereas everybody else will sorely feel it. And, in a tough world where our standard of living is so high and everything is so expensive. I mean, I think about, we used to have phones for $8 a month. Now, granted, you couldn't call across the country. You'd have to get long distance. But do you remember when TVs were free? Analog was that? I don't know. And now we pay for streaming. We pay for this and we pay for that. Phones, we have better technology, but we pay out the yin. So we have very little disposable income after we pay for the things that we take for granted as being bare bones necessities. That's just my perspective on that. So I think it would be very painful for them to increase taxation for Social Security on the workers. All of us still working anyway. Okay. But I don't think it's going anywhere, Graham. I don't. It will not. Marcus Wallace. I'm in the Dead Streamer responding to Marcus. I'm going to step out. Maeve thanking Brian Kimball for his service. I agree, Maeve. Thank you for calling that out. Okay. I think George is the repeat. Do I think retirees should get free SNAP, Medicare, and property taxes? I don't know. I'd have to delve into those things all interestingly. And what about wealthy retirees, George? Should they get everything free too? Free means welfare. It means someone else is paying for it. Should wealthy people have it paid for by poor people? Because remember, retirees are not all poor. So I feel like we have to differentiate. You follow? Marcus Wallace, again, says, I was going through the SOAR program to get mine, but thanks to Trump's bill, the program lost funding. So now I have no clue what is going to happen. SOAR program, I'm not sure how much they were relying on taxpayers as opposed to donations. So that's unfortunate. And I'm curious if that's actually accurate. But anyway, hold on. That's supposed to be silenced. Dreamers Club says, my hearing is in 9 days. I'm so nervous. My lawyers say I have good, strong evidence in my file, so I'm hoping for the best. Well, I'm hoping for the best for you too, Dreamers Club. And if your lawyers think it's good and strong, it probably is. So kudos to you and fingers crossed for you. I hope you get a win. John's Travel Adventure, back again. My lawyer has filed the 1696 form 3 times. Oh my gosh, this happens to me all the time, John. And still no response from SSA about being added to my case. Does it normally take 2 months for this to happen? Very often. It is so infuriating. This has been going on a few years. I'm hoping it's going to be remedied soon. I get some that are done perfectly. So this is not all of them, but it is some offices, and it is pathetic and disgusting. And you know what? I wouldn't have a problem going to a congressperson and saying, can you put a light under their arse They haven't, because here's the thing, if you have a case going on, and this is what I say with the clients I have that already had started cases by the time they came to me, their case is moving on. And I'm not able to see what's in that file because these doofuses did not do the very simple, and this is not a time consuming thing. This is a couple button presses. I don't care what to say. It's very quick. I mean, it should be done same day they get it. Totally same day. I resend to, and I don't know if it goes into some big old scanned fax receptacle and then some slow person eating their bonbons goes through it slowly. I don't know. But that is something that I think is a violation kind of the due process of the person that appointed, like in this case, you, John, because you retain a lawyer or a representative, I'm not sure which, lawyer, to be doing this work for you. And you're getting gypped. And he's getting gypped because now he's doing all this extra administrative stuff to get your case properly moved forward with his representation. So it's like a complete train wreck, and all they need to do is press a few buttons and get you connected. So I would, if it's been 2 months, I tell my clients, call your SSA and tell them to get my stuff processed. You know, be nice. I always say honey, not vinegar, because you don't want to tick anybody off because you got little people in there with a lot of button power, even though they don't have official power to do that, but you just don't know what they're going to do. And just gently say, listen, my case is going on. My lawyer's not connected yet. And so I have I need this to be connected so he can see what's going on. I feel really deprived of my ability to have my case properly worked up because your office hasn't processed this. And be sweet about it. Be nice. Don't ever go off on them because it will not help you. You can complain later in a letter, to even the OIG about waste, fraud, or abuse, but I would do that. And I would also, if that doesn't render anything within a few weeks, go to your congressperson through their help with a federal agency and put all the dates that he sent them in, that you called them, and then say, can you please get them to process this? Because my due process rights to pursue my case are being disadvantaged. That's what I would say. And I do say it. GC 24 styles. You can get SNAP while you wait and get cash, but your doctor must defer you from all work and job training for 12 months due to your ailments. I'm gonna rely on you for that, GC, because I don't practice SNAP benefits or that, because that's all local stuff, guys. So the locals need to be in charge of that. So, and I would say, guys, your states have control over that. So even if certain NGOs were deprived of certain monies that they were getting for free from the federal government, which meant your state SOAR was getting money from people in California, a little bit of unfairness to it, perhaps. Your state has the complete power to fund things. Whether they choose not to, that's the state you chose to live in. So you might want to look to your state representatives if you're unhappy with what they're providing. That's your immediate go-to. Oh, wow. Maeve says that her PT that she was referred to, it's like the only game in town. Can you go out of town, Maeve? No manipulation. They didn't do anything. That's not physical therapy. That's some guy with hot air coming out of his mouth. Go home and do exercises. Bull. And he got paid. I would, if you got paid from your insurance company, I would be maybe reporting him. Maybe that's not worthy of a payment. That sounds like insurance fraud to me. Dismissed after 10 minutes with exercises increase. That makes me really mad, Maeve. That makes me really mad. I would, well, if you have the energy, I know you got bigger things to fry, but maybe it might be worth going a little out of town. I know you're rural. I get it. But, I'm not even that rural. But, like, when I had to take my daughter to vocal cord therapy, I had to go an hour and a half. Fortunately, it was the type of thing as they had excellent things you had to do anyway at home, and they really made a difference. So it's a different kind of, obviously, therapy where I think with bodily stuff, you really need someone there spotting you and pushing you, gently within the capacities. But so what a schmuck. Maybe talk to the orthopedist that referred you. Orthopedist, right? RD says, hello from California, just logged on. Hi, RD. The Dreamers Club says, I'm on oxygen. Okay, so now we go. Thank you. Because pulmonology, a million people go to pulmonology for asthma, and they're not on oxygen. So oxygen does make a big difference, particularly if it's 24/7. He says he's on oxygen, so he put the strictest on all physical things except smelling, hearing, and talking. And I bet you run out of air if you're talking a lot, right? You'd think I would, the way I talk so much. Psychiatrists put that I can't follow a schedule and all that sort of stuff due to too many panic attacks. Excellent, because that would be a psychiatrist thing. I thought you were saying psychiatrists said that you can't be walking and you have to be lying down all the time. That would be very strange. So yeah, that oxidant and how much it is and how often is big. Now, that doesn't necessarily mean less than sedentary. So if you have like sitting, now it might be hard to get the SSA to believe you can't be sitting. but oxygen does help versus just a pulmonologist saying it, particularly if it's 24/7. And if you have other, I didn't catch your age there, Dreamer, but if you have other physical problems, you need to start following them aggressively. Like if you have an aching back, get the MRI, see what's going on. Depending on what it is, all that can help show that you really can't do the sitting job. Between the breathing, but then does that mean you're lying in bed all day? Seriously, like that's the only, you're either standing, sitting, and standing would include walking, standing, sitting, or lying down. So you have to figure that one out, right? And it's going to be hard to show that you can't sit up on oxygen. The walking, I get. That's physical, of the cardio kind. But the sitting up is going to be a little tougher, I think. There he goes. Thank you, Dreamer. He or she is 54 and turns 55 the month after my hearing. I wouldn't be surprised if you got one of those age category changes a tad early. Very well could. I forget if you have a lawyer. Hopefully you do. If not, and if things go sideways, that might be something to appeal. So if you don't have a lawyer, I think you do. But if you didn't, you do know how to reach me. Brian says, I am going through my medical records to make sure my lawyer has what is pertinent to my case. I do have medication side effects. I've been prescribed a walking cane. Awesome. Not good that you have problems walking, Brian, but I would also say about the walking cane, only because I've seen this come up very often, if not most of the time, sometimes they will make a discrepancy between someone who needs a cane for walking and someone who needs a cane also for standing. So if you need it for balance when standing, hopefully that's in the record a little bit, for balance, needs a cane for balance as opposed to just walking. That could be very helpful because sometimes I've seen them try to say someone could do bench work, do assembly line stuff, like the little things, because they don't need their cane to stand and they can use two hands. But if you need your cane or your hand to hold, to keep you balanced when not even walking, that would eliminate a two-handed job at a bench. So just a little tidbit of trivia there, guys, but it's really important for a lot of cases. All right, RD says, what time are we at? We've been in an hour and 23 minutes. All right. RD says, is fibromyalgia a hard diagnosis? Oh, yes. And did you see the video that came out? I think that was yesterday. It was a case that came out that I was discussing. It was very good for fibromyalgia people. But yes, it is a very hard diagnosis. It is not a well-respected one, although the SSA acknowledges that it is in fact a diagnosis and an impairment and has to be addressed. Can a neurologist diagnose? Even a primary care can, but the more credible comes from someone who is a fibromyalgia literate doctor. Sometimes it's a rheumatologist. But indeed, if they've done all of the acceptable medical diagnostic criteria for fibromyalgia as it is today, and I do think it recently changed, even with the SSA, the way they all acknowledge it, might not be needed, those trigger point 4 quarters thing. But don't hold me to that. But they did change it in the last few years. If it knows it, so could a neurologist, but he better explain how he diagnosed it. He's going to have to go into it. And I don't know that a neurologist is going to want to do that. Usually it's a rheumatologist or someone who is otherwise very literate with FMS, which is not really that many. Some don't even believe it to be so. They think it's all in your head and you're just a nut job. It's very rude. So, I mean, it depends if he just says he probably has fibromyalgia, that's not a diagnosis. It has to be an actual diagnosis with all those steps it takes to diagnose it under the medical association. You are taking Lyrica, nortriptyline, and Celexa. Yeah, and those are often for fibromyalgia and other things. I'm getting treatment for chronic nerve pain, but not diagnosed with fibromyalgia. Chronic nerve pain, I mean, if it's not fibromyalgia, if you can pin it on something else, that might even be better, RD. Neuropathy, peripheral neuropathy due to nerve damage. Maybe it's due to diabetes. Maybe it's due to radiculopathies coming from spinal impairments. There can be tons of other reasons. I've even seen it like post-viral. Before and after COVID, guys. So it's not just a COVID thing. Post-viral syndromes, we're not born with COVID-19, contrary to popular opinion. I had cases that were post-viral syndromes long before COVID. It just got very popular then. Shoot. Saw on another channel, there's no such thing. Yeah, we just talked about this. Yeah. So believe what you want to believe. There's different channels. People say different things. So your word letter says 5 to 7, and all the SSA rules talk about 5 to 7. So I would tend to go with the source and not someone who's just saying there's no 5. What he might be saying, and I think I talked about this before, Shoot, maybe you weren't here earlier because someone brought it up. I don't think it was you, though, was it? Because the SSA is always so slow and backlogged. I mean, even in the best of days, it's never perfect, right?
It's usually quite a few steps from perfect. It's just what we think is much better now because we're so used to seeing horrific things. But it might be that 5 to 7s tend to be 7 years. They're saying for practical reasons, even though they say they might do it in 5, it just tends to be 7. That is probably likely because of lack of resources, backlog, things of that nature. And another thing we had talked about was if a medical technology changes and it's causing people great relief over some disorder, condition, symptom, and that, blows the media away and the medical world, that could be a reason to do the 5-year on that instead of the 7-year, because they want to know if that person has had that treatment and how they're doing. If that treatment is very like it's discovered, they're using it and blah, blah, blah. I'm just going to give an example because it's the only one I could think of off the top of my head. Obesity used to be a listing, significant morbid obesity. It is not anymore. I think that's how it went. Now, imagine if Ozempic was around back then and they had a person on a 5 to 7 with this, they were 500, 600, 700 pounds, whatever. If Ozempic came about and most everyone that's morbidly obese seems to be, when everything else fails, they go on something like Ozempic or whatever the generics are. So if that was discovered back then, don't you think they'd be like, maybe this guy has lost weight because, it's been a few years. We have him on a 5 to 7, so we'll do the 5 because, and lo and behold, the guy's down to 220. Is he really still disabled? If he was disabled by obesity and only obesity, now it's not a listing anymore. So that's why I said this is kind of the only thing I could pull out. But that's just an example of how medical technology could completely change the time frame. And why a 5-year can happen on a 5 to 7. My thoughts are that it could also have to do like with prosthetics. In theory, if new technologies come out that make some people, even with prosthetics, they're still disabled because they just somehow it doesn't work very well for them. It could be a lot of skin irritation and flesh irritation and problems. So you have to really prove a lot with an amputee, like a leg. You don't just win it because you have a leg amputated. And most people with amputations are totally fine to go back to work in some shape or form. Maybe they're not going to be able to do what they used to do. But they could have new technologies with prosthetics that now work for these people. And that could then change the dynamics of the 5 to 7. You see what I'm saying? Capish? Okay. Thanks, Shu. That was a good question. Would they do a CD? I have never seen that happen. I can't say I've read one way or another whether they can, though. So I'm not going to say it. But I don't think they do. But I don't want to say that because I don't really know. I haven't seen it happen, but I haven't researched it. Good question. Good question, Shu. The art of practice. Good to see you, Art. Are bilateral hip labral tears with balance issues, autoimmune complications, and use of prescribed cane likely to qualify as less than sedentary? I take it you're under 50, Art. Therefore, the importance of less than sedentary for you? I would like to think so because goodness knows sitting is going to probably hurt. I mean, the autoimmune complications? Get into the weeds on those. Is it a massive fatigue thing where there's also naps required? Get the medical proof of that. Talk about it with those doctors, blah, blah, blah. Just got to go into every single symptom, really, and get it kind of drilled home in the medical records. Balance issues, if bad enough, can create less than sedentary if a person is not even stable in that 1 to 2 hours required that they say you might have to be on your feet in a sedentary job up to 1 to 2 hours. That's why they say sedentary is only sitting 6 out of 8, not 8 out of 8. So if that's the case, if the balance issues are so extreme that you're with a walker, double-handed, 2 canes, or a wheelchair when you want to do anything but stand up with a cane, say, that could, so it really depends on how extreme these things are. It's within the realm of possibility, but they have to be really extreme, I would say. I'll tell you, they hate that word less than sedentary. So many cases I know they can't do sedentary all day long, but I have to still, even though I know they're less than sedentary, I have to prove that they're limited. I have to also prove that they win their case if they're found sedentary, because that's what the SSA is probably going to do. So this is where I say we have to prove this case and this case and this case for this one person, because that's the way they might go. So we have to have all those avenues blocked off for them to deny. It's a little crazy. All right, I'm not going to go into SOAR, but I will say, why is your state not paying that? I don't understand that. I mean, yeah, I don't get it. So I would complain to my state people. Like, come on, take care of your state's people. That's what I would be complaining. John's talking about, and I was just referring to Marcus. And you might want to look at why they were deprived of some, if they were, Marcus, because there was usually a reason for it. So maybe they were up to something that was no good, and it screwed the other thing. That's why you have to be really serious about these outfits and doing the right thing. I have called SSA twice and still no response from the 1696 from my lawyer. So you spoke to the SSA and they said, oh, it's in line to be processed. Is that what happened, John? Now I'm going to call my local congressman and file a complaint or voice my complaints to him. I would do more than call. You know what I would do? So you have documentation. I would go to his website. The one where he has somewhere in there in a menu item is help with a federal agency. Because he's gonna need a release from you. So you're gonna have to do this in writing anyway. Just calling and complaining isn't gonna help your case at all. So do that. Put down the dates when you called and when your lawyer did that he sent in the 1696 and what day you know, all the dates. And they generally do make a congressional inquiry. They can't change the substance of your case, but when something is a cog in the wheel of process, they will play to match. And often we see, I'd say 9 out of 10 times, it used to be 10 out of 10 times, we'd see immediate action. Through 2024, that didn't happen, at least on one major case of mine, which was atrocious. But yeah, that congressman, but I would do it through his website. So he gets that because it's going to want you to do a release. And you could do that probably digitally, maybe, okay, or email. Yeah. All right, Shub. Shub says, yes, my favorite 3-letter derogatory word is back. Did I say one? Which one did I say? I don't know. Okay. For Dreamers Club, his oxygen. Okay, so Dreamers Club, his or her oxygen is 24/7 continuously. I am so sorry, Dreamer. I know that's not fun. He put, I can sit, but everything else is like 2 hours out of 8. I can't walk from one room to another without losing my breath. Is that with your oxygen you lose your breath? Even with the oxygen? That could be significant. I mean, that's dangerous, right? Your body needs to be oxygenated. Dreamers Club is also on 16 different medications for various issues and lots of side effects, such as fatigue all the time, and it's noted across all doctors. Good. More than once, right? Complain about it every visit. Oh, hi, Shub. Joy to the world. Yeah, we sing that. And Jeremiah. Yeah, Jeremiah was a bullfrog. Yep. Since I was a little kid. Jeremiah. Okay. RD says he has neuropathy from the spine. I have the nerve tests in my medical records and MRIs. A neurologist is treating me. Okay. So that doesn't sound like fibromyalgia. And honestly, maybe it's better that it doesn't, because this is objectively proven and fibromyalgia is still not. So I think that's better, RD. What do you think? Marcus says, I had a psych exam April 16th for SSI. When should I hope to hear back from the SSA about my claim for SSI? Whenever they get through getting all of your medical records, and hopefully you're vigorously treating, Marcus. And then, because I assume you have Medicaid, and then the psych exam or physical exam, if it's a CE, is usually the last step. Sometimes they got a few more things. If you told me, yeah, but I went to my doctor after and he did an MRI, then you're going to want to give them time to get that, or you get it yourself. But then once they get everything and it's getting cut off in terms of the additional medical evidence coming in, they ship it to the MD or it could be a psychiatrist or other doctor who does the review of all the medical records and then produces an RFC. Might even see if you're a listing, and then if not, which usually it's not, produces the RFC. Then it goes back to the adjudicator because now they have an RFC, and they continue the next steps. Step 4, step 5, because the RFC would be done at step 3. Tanya Faye, nice to see you, Tanya. Should I cancel my hearing because of it being regarding SSDI benefits? I don't even know what this says. There would be the judge B eligibility. I'm separated now and have been since January. I have no income and determined medically. The work credits owned my business. I have no income determined. Okay, I don't know if you guys can figure this out. The work credits owned my own business. Okay, owned your own business. You should have plenty of work credits. Then correct. I don't have any income and I've been determined medically disabled with 4 different neurological disorders. All right, so it sounds like you won your case. So I'm not really sure what the question is. Why would you cancel your hearing? Well, first of all, what is the hearing for? If you've already been found disabled. I'm not sure what's going on. Sorry, Tanya, I don't get what's going on. Christian Hendricks says, hi, I have an appointment on August 28th on the phone this month. Do you mean you have a hearing, Christian? By the way, I have an uncle, Christian, and a nephew, Christian. Just saying. I think one is spelled with a K and one is spelled with a C, I think. Well, so it sounds like you have a hearing on the 28th, a phone hearing. Good luck with it. I hope you win. Okay. All right, Tanya, do you already have SSDI benefits? And then for some reason you were trying to get SSI benefits on top of that, or that's a financial thing. you're already disabled, you don't need to go to a judge to find out if you're disabled. If you've already been found disabled by the SSA and you're getting one of the benefits, and now you're saying, I want to get the other one, all you have to do for SSI, if you're already disabled, found disabled, like you said, unless you meant not really by the SSA, but by somebody else, that doesn't count, SSI would automatically get you SSD if you had the credits. If you didn't pay taxes on that self-employment, that will come bite you in the butt. And that's why you might be, if you don't have SSD, that might be why. But if your SSD is high enough, you're never going to get SSI because it's only for the very poor with little to no income. Christian says he has osteoarthritis in my right ribs, cerebral palsy, all of my left side, and I have pain in my spine. Ouch. That doesn't sound fun. Yeah, good luck. It's hard to know. I mean, I know people with CP that work, and then sometimes something happens and things get worse and they can't work. So it really depends on the severity of those ramifications of that particular disorder. Tanya, you didn't pay your taxes. Yeah. Just to go into this, guys, Tanya's saying she had her own business, but she didn't pay taxes. Aside from some other troubles that could be leading to, Tanya, so I worry about you a little bit there. When we work under the table, guys, aside from it being an IRS violation or IRC violation, if we have income that should be taxed, but we're not declaring it, we're not going to get the credits that would come with that income taxation because SSA taxes are all on our working income. That leaves us uninsured for SSD and potentially for Social Security retirement. And at the very least, if we were insured for Social Security retirement, it will become smaller and smaller as we approach 62 and we don't have much paid in because that's the amount we get for Social Security disability and the Social Security retirement is entirely dependent on how much we pay in over the years. So when we don't do that and we evade taxes or whatever we do, in the end, we often will pay for it. Unless we are independently wealthy some other way, that's it. We are choosing not to pay the premiums for this insurance of disability insurance that we really might end up needing. And retirement is also is insurance. So either way, whether we pay very, very tiny premiums to get a little tiny bit of retirement, or we decide to pay our taxes all along and get something higher, we all make our choices. And it's difficult. It's unfortunate. Do know that if you find yourself not insured for SSD, we have videos on this, you can always gain those credits back that you would have had for that recency test that's also required for SSD by starting to work at that minimal part-time. Right now, $7,500 a year will get you all 4 credits. You generally need 20, most of us, except for the very young people. So 5 this year, 5 next year. In 5 calendar years, you will have your 20. At the very least, you might have them quicker because maybe you do have some still in your last 10-year window. Tanya says, no, not for the last 10 years. So you would have to do 5 years of actually paying taxes on at least part-time work. Sometimes it's easier to just do a 2 part-time job, and then you can gain them back. Ideally, you can get 4 a year so you can get them back within 5 years, So that's probably what I would be telling my client, although I don't know all of your situation. But I'm not sure. It sounds like you didn't have SSD and your hearing is about SSI. I do wish you the best of luck with that hearing to find that you were disabled. So it sounds like you were never actually found disabled by SSA. You just were told by some people that you were disabled that aren't in the SSA program. I might not know the definition, but yeah, if you are on SSI eventually, Anya, and you want to move over to SSD, again, you could still work part-time, stay within the rules, know that some of your SSI is going to be offset and you're going to owe it back, but it's still going to be more lucrative than not working, and you can gain that SSDI status back. So just saying, something to look into if that's what you want. Okay. Yeah. Tanya says she had no SSDI benefits. She didn't have a payroll. Yeah. So here's the thing. I'm self-employed too, Tanya, and I have a business and I file taxes, and all the revenue I get in that is more than the expenses I had to pay out to get it. Everything I used to support myself and pay my rent, well, my mortgage and whatever, that's part of that's my wages I have to declare. Everything that comes to me that isn't, replacing what I paid to this computer, for instance, or the internet I used to talk to you guys, that's all income, that balance, the net earnings after self-employment. And I pay obviously regular income tax on that. And I also pay Social Security taxes on that so that I continue to get my credits. I will always be SSD insured. And of course, now I don't have far to go for retirement. Although I hopefully will wait till I'm 70, but we'll see. We'll see how the health goes. So you could change that trajectory you put yourself on if you want to, if you're able. Sometimes we get so disabled, we can't even do that. So hopefully you're not at that point. You're just not able to work full time. And so you would be eligible for disability. but you can still work when you're on disability if you follow the rules. So be very, very careful. RD says, I agree. Joy to the world. Oh, thanks, RD. No, Tanya, it's not the payroll you would pay for employees. It's your own income. You have to, it's not pay, you're not, unless you're a two of your own business, you need to go speak to a tax person who's Social Security literate, perhaps. Whatever you pay, you paid income taxes, you should have been paying Social Security taxes. I don't know what's going on with that. You don't need a W-2 to do that. You don't need a 1099 to do that. You just see the income comes into your account. I have people who pay me outright for a consultation. I'm not getting a 1099 for the SSA for that like I am for everybody else, all my clients. But I pay taxes on that. I report that in my income. Yes, I have a lot of expenses that come out. So whatever comes out, but there's still a nice chunk I have to pay the taxes on. And I actually kind of want to, because I want to have a good retirement, or gosh forbid I become disabled. You know, we all make our choices. Do you want more in your pocket today for more spending today, or to save? Okay. Just be careful of the tax laws too. You don't want to violate them. Spine surgery journey. Hey, I know you got an attorney, you said. Start a recon with the attorney. There are 2 missing doctors. They didn't get any information from my surgeon and my primary. And your primary, I guess. That's crazy. That sounds like 2 major things. So who knows? Maybe you can get this flipped on recon. I don't know if you were here earlier, fine, but I just had a word last night that my girl won the medical battle on recon. And it's been a long haul. It was a long initial and recon. I can't remember if she might have filed her own initial and then I was in immediately, or maybe not. I can't remember. It's because it's been like a year and a half. Okay. Aunt Lizzie, nice to see you. See you live on here. I have a phone interview tomorrow for my son who just turned 18 and has been diagnosed with fetal alcohol syndrome. He can't hold a job. Does SSA always deny on the no? Not if he has the goods. I've heard horror stories. Yes, because if you don't have the goods, you'll be denied. It is very, one can't just say, I can't hold a job. Because remember, it's not holding a job that defines us as able. Let's say we get canned after 8 months every single time. So we work 8 months this year. We have 2 months off. We work 8. That's not disabled. We have impairments, but that's not disabled because we're able to do sustained work. So it really depends. You got to be careful of the language you use officially. I know here we're just babbling, but can't hold a job. If he's earned SGA at those jobs, that is sufficient work to not be disabled from performing SGA on a full-time basis for any job. So, or SGA on a part-time. So any part-time work would have to be under SGA. But fingers crossed for you. I hope the best. I know fetal alcohol syndrome does a number on many, many capacities. So I guess it's just time to see, where that falls. Has he been a diligent treater for all of these symptoms? Does he go to the doctor regularly, a specialist for his particular special problems? Has he had occupational therapy for them and physical therapies and all that mental health therapy if he needs it? Where does it all fall? We can't just say it. We have to actually really, really do it hard, particularly if he's under 50, which I guess he is, right? Aunt Lizzie, is he young? So spine surgery journey continues to say he had procedures, pain management injections, I guess an emergency room visit after the application. Well, if you told them about it like you were supposed to when you were self-representing spine, you were supposed to tell your adjudicator when you had new places you went to so they could go order the records. The records don't just fall out of the sky, right? But I do think if you had missing stuff, and also it's going to depend on your vocational profile significantly. You look young there, spine surgery, so I don't know. Are you over 50 or under 50? Makes a difference. Over 55 makes a difference. Yeah, Tanya, I know. It's tough talk, so I just wanted to put it out there for you. But you can, and if you're not completely bedridden and you can do even like gigger work, I discuss that a lot in a lot of other places, even house sitting, you can, and you pay the taxes on that. Don't write it all off so you have zero taxes. You pay and you earn like $7,500 a year this year, and it's going to go up a little bit each further year. You can change that and you can have SSDI insured status. And then if you're still disabled, your SSI can convert to SSDI as long as you're still disabled, provably so. So you always want to keep up that evidence too. And your retirement will therefore be bigger than it is now. Okay. But I just feel like it's important to speak it like it is and not just sugarcoat stuff, because this is your life. You need to know this stuff. I think you made a mistake with your business, not on purpose. You just didn't know. And I just want you to know stuff so that you can maybe change that trajectory, particularly if you're a young person. You got a lot of years to go to 60s if you're young, even if you're in your 50s, you got years to make up. You can improve this situation if you're not bedridden. Okay. There are ways. Art of Practice says he's under 50, can stand 5 to 6 minutes and sit only 20 to 30 minutes before significant increase in hip pain, stiffness, and catching when standing. Have MRI, PT, surgery notes, etc. What is best way to present case? Well, that would depend entirely on the specifics of that medical evidence. That's why how we present the case is so time consuming to strategize about presenting the brief, which is basically how we want to put the strongest stuff in that brief. You can't like put every little nook and cranny because you want 2 or 3 pages out of sometimes a 3,000 page medical file. But there's strategies to it. You know, I can't speak to how you present your case because I don't represent it and I don't know it. I'm sure listening to all the videos and stuff, it can give you some ideas, right? Dreamers Club says, okay, I think he's referring to the tax situation. I don't think she understands that when you do your taxes at the end of the year, they automatically take that as Social Security tax. So she probably has paid it if she has paid her taxes. No, I don't think that's the case. And here's why. If you have your own business and you're self-employed, the money that you take for yourself, for, you know, your profits that you take and you use it to support yourself, that's your income. Net income from self-employment is when you make your 50,000, then you say you have 10,000 in business expenses. It could be mileage, whatever's legitimate, and that knocks you down to 40. When you do your tax return and your Schedule C says revenue minus my business expenses, I can write off, leaves me 40. That's going to be what your Social Security tax is going to be based upon. It's not what your federal income tax will necessarily be based upon because you'll have deductions. You get your standard deduction. That's separate tax, separate part of the whole April 15th tax stuff we do. But the Social Security tax is only on what comes at the bottom of that Schedule C. So if you have your $40,000 of revenue from your business and you write off everything, you say, I made 50,000 in revenue and I can write off $50,000 of business expenses. So I get to pay 0 income taxes, which is not Social Security taxes, income taxes, woohoo, to the state, to everyone. I get nothing on that. Well, power to you. You wrote off enough to do that, and hopefully they were legitimate, and they could very well be. There are a lot of expenses, but you just, by doing that, you did not have the opportunity to pay for premiums for Social Security disability or Social Security retirement on that income because you chose to have none left over that could be taxed for Social Security purposes. And so you had 0 credits that year, and every other year you did that, and that's why she's saying she did it for at least 10 years. She has no, you need 20 quarterly credits in the last 10 years. Technically, there's 40 available. You only have to work half of that, which means half of the 7,500 I was referring to get 2 a year. And then you would earn them all within 10 years. But if you earn all 4, you can earn them in 5 years. She scrolled out that 10-year window for SSD. She can earn them back, if she wants to, if she's able to. But she would know. She has an SSI case right now, Dreamers. And SSI, if you file for it, they automatically check to see if you have SSD insurance status because they don't want you taking welfare if you've got your own insurance to draw from. So that's why I can, with a fact, say she didn't pay in. And she knew it. So she didn't get those credits. But she could change that trajectory. I just think it's a better future when we do. Being on Social Security, by and large, is an easier go than being on SSI. You don't have that thumb on the pulse of your neck strangling you. SSI is better than nothing, though. Double C says, hello, what does the doctor ask in a consultative exam if you're mentally disabled? Yeah, well, they all might vary a little bit, but usually all the kind of things a doctor would say when you first go to intake with them. I do have video on that. If you want to go look up consultative exams, I think might also be under these are the playlists. Double C, there's a ton of playlists. They're kind of messy. I keep telling people I'm going to straighten them up, but I never have time. But there is actual videos discussing a little bit about what to expect at your mental consultative exam, as well as your physical. So go check them out. Tiffany's Attic. Hi, Tiffany. Thank you for your video on fibromyalgia. Yeah, that was great news, that one. And many others. Thank you, Tiffany. My daughter suffers from this debilitating condition of fibromyalgia, along with other conditions. Your videos answer some of our questions and helps. Well, I'm glad. Helps us understand the process and what we should expect from her lawyer. She has her court date in October, and all lawyers are different, though. So just the way I practice things might not be where others do. Just don't necessarily shoot them in the foot if they do things differently. I'm just very anal, as some of you know. She has her court date in October. Thank you so much for your time and expertise. fingers crossed for your daughter. And I'm really sorry she's suffering from that and other things. It's not, chronic pain is such a debilitating thing. It really is. Aunt Lizzie says, thank you. He has never had a job. He forgets everything. The psychologist said he can't hold a job unless it's one-on-one and he can't drive. Hey, Lizzie, by the way, my mother's name is Elizabeth. We used to call her Lizzie Borden, just to be wise guys when we were young. I'm sure you heard that, right? He forgets everything. Has he had a battery of tests about the memory and or the other functionings, like a neurocog or a psychiatric cognitive battery workup? That might be something to think about, to show how scatterbrained he might be. Psychologist who hopefully knows him well and has this in his records, perhaps, like, because he's saying he can't hold a job unless it's one-on-one. I think meaning he needs a lot of direction, a lot of hand-holding, maybe excessive supervision to hold that job. If you can get that documented in a way that's really strong, maybe even getting him evaluated by like a vocational rehab or something, how much accommodation would he need to get one of those accommodated jobs? If you can get someone who evaluates him in that vein, like, well, does he need accommodations to work? And if so, how much for a successful work experience part-time, not just to throw him into a job that he's probably going to fail at. What would be the best accommodations? Would he be best served and the job get done best if he has a job coach there with him, which might be that one-on-one, or, so the supervisor doesn't really have to do it. And the specifics of why he can't hold that job, you have to be really, it has to get into the weeds there. It just can't just make that summary of can't hold a job. The psychologist said that it's not going to work, I don't think. But if he says, when we have our conversations, he gets distracted very easily, I have to draw him back. He doesn't even hear me talking to him because he's looking out the window. Specifics can be really, really good. Umo says, has there been any noticeable change in response from any level of SSA, local offices, ALJ, processing departments due to all the loss of personnel? Too soon to tell. Well, Nosker put out a chart that showed that since the end of 2024, it has the wait time, I believe, has slightly gone down. Then the SSA put something out. I'm going to do a video on this probably today. Knock on wood. I'm hoping I get to it today. I kind of want to get out another appeal, but we'll see. It was some very good news on, I think it was backlog. I don't want to speak out of turn. I was reading it, but I blew through it because I'm like, I have to come back to this. It came out on July 8th. I'm gonna announce it at least because it gives us some hope that things are doing well. Because remember, the loss of personnel was supposed to be for those that don't do the hands-on stuff. It's like the recipe creating department. The excess where two people are doing the job that one person used to be able to do, that kind of thing. So in theory, the loss of personnel should not be worsening the backlog and the wait times. So is that bearing out? It seems to be starting to bear out. I will get to that. I will post that, guys. I will try to bump it maybe in front of something else that's not maybe so on point to that and, put that in another slot. But I believe it is helping. I'm not sure about ALJ. I'm trying to think. I just got ALJs seem to be like, okay, so my ALJ appeals of say 3 months ago are now finally getting scheduled. And so I have one that just got scheduled for November. I had say a month ago, some scheduled for October. So it looks like for where my cases are, which is kind of all over the country, it's a little mishmash, right? But those were all, that's not too bad. I mean, in the mid-teens and 20 teens, when we filed an appeal, we waited like a year and a half to even get something scheduled for a hearing. It was really bad. And then they fixed it up. And by 2019, summer of, it was pretty good, like 5 months, you got a hearing, and then it has gotten worse since then over the last few years, but not as bad as it was. But so when I'm talking about the things I was talking about, I think I was talking about initial and recon, UMO. So I will get that because I think it is interesting and I want to see, because if all the inner word I was getting is that the personnel change is the, if you need two people to do one person jobs, there's a problem here. And the departments that literally had nothing to do with helping claimants, zero, that is where my understanding was they were coming from. So if that's what's happening, that would explain why things are getting better, I suppose, because that would mean that the customer hands-on departments have actually gotten more robust and workers and not reduced at all. It's those other areas. So I guess we'll find out as time goes on, right? Let's see. Do you have any videos on the Form 3441 on 56. Now you already appeal. That's the appeal form. 3441, guys. That is for appealing recon or appealing ALJ, for ALJ hearing or for appealing for recon. So it is normally done, Spine, online when you appeal online. So we don't really call it that when it's online. We just say online appeal. Of course, up until a few years ago, we didn't have online. So we were always doing the 3441s. I don't know if I have. It's kind of self-explanatory. I know I do data gathering. My people are heading towards an appeal. I have a data form where I collect everything I'm going to need to do their 3441 or their online appeal. I ask questions in a slightly different way than what sometimes what the 3441 actually says, because I want to elicit more information that the 3441 isn't asking of them, but I know is going to be helpful to their case. And for whatever reason, the 3441 doesn't ask it. I have in my data form tips for things for them to think about when they're answering this question. I even sometimes throw in a link, but like things to think about when you're answering the question: has your condition changed? Ways to look at that and things to think about, because people oftentimes will just be like, no. And I'm like, well, are you sure? Because we were talking the other day, So my way of gathering the information for the 3441, because we do the appeals, we don't have our clients do any of that stuff. In red, we have these little like highlights explaining a meaning of something. And that's how we get some of the more thorough answers that you might otherwise see. But I could probably do a video. I'm not going to share my data form. That's just for my clients, but I could do a video on, explaining it. Maybe I'll do that if you want. But I don't think you really need that because you have an attorney. So you're not, did you file the appeal already? Or they're going to file it, right? Anyway, that's that. But if I do get one, just keep an eye out and it'll say for how to fill it or something like that. All right. I'll try to get that done. Double C, you're welcome. Ooh, 6,000-foot Mike. How are you, bud? I've known of self-employed people who have non-professional tax preparers satisfy the IRS, but never mentioned to the person that they need to pay FICA. Well, when I send my check, and I have estimated that I thankfully do, but I always have to pay more at the end of the year, probably because the business has always been growing over the years. And, you just I don't really assume it's going to be bigger. I try to tailor my life to not be presuming that, so that I don't get over my skis on that. But when I pay the amount that say a TurboTax, and I did have a tax preparer, and then he actually screwed up. So, but in a different way, not in this way. When we send our check, Mike, the government actually puts it where it needs to be. I send one check and it gets divvied out. So the check that the system says you owe the federal government X amount, that's one check. I don't have to pay it twice. I don't have to break it out into what would be my FICA. In a self-employed, we pay double what workers pay. They get the benefit of corporate actually foots the bill for half of your Social Security tax. I know everyone says they don't pay taxes. I'm like, you have no idea what they do, people. They pay half of every worker's Social Security tax. Anywho, but I do know I pay one check, Mike. So the amount that it tells me to pay combines both. We don't have to divvy it up. I don't know how to explain that because I'm really not that proficient, but that's what I find funny, that his bottom, the tax preparer, I don't know how that didn't, maybe people should, I'm not trying to toot TurboTax's horn, and there's other companies, but maybe that's safer than sorry. Believe it or not, I used to do my own taxes, and then I used to give it to my tax preparer to see if they jive, because that's how I was. Now I'm just like, I'd rather just pay more in taxes and not spend all the time. So a lot of stuff I don't even bother writing off. I'm like, no, I'm not going to fight over that, blah, blah, blah. I'm not going to go collect receipts for that. Too bad. Including the home office. I'm not keeping the receipts and doing the math and all that. I'll take the $1,250, which is a pittance, So, and it's just a deduction. It's not like a credit or anything. But I used to spend so much time on taxes. It was the bane of my existence, and it used to make me miserable. And then I started getting extensions because that's how much I hated it. And then I was finally like, screw it. I'd rather pay an extra few hundred in taxes. It's my time, my life, Umo says, I know a few people from my local office who took the DRP, delayed retirement program, and said that other people will be reduction in force before end of fiscal year. We can only hope so. Yeah, let's get more efficient. Seems to be working. Okay. Yeah, some people, thousands of people in the federal government took the offers of take this lateral move. We need people here, not in the basket weaving department. We need them in the field office. We need them here, whatever. or, and by the way, remember guys, DDS, all your adjudicators, they are not federal workers. So when you're wondering why the DDS is so slow, part of the reason is the state has not kept up a little bit as well. Although the state gets money from the feds to pay the DDS workers. DDS for the feds, but right, and with the federal laws, those are all state workers. Those state workers, each state has their own disability programs also. So that's where these people come from and all that. But when they work on federal cases, they have to apply the federal law. And I have a feeling they're dedicated to that. They're not maybe doing both, I would imagine, because that would get a little bit confusing, I think. Tiffany says, very hard to find a rheumatologist that treats fibromyalgia. Yes, I agree. She waited 6 months and then was told he doesn't treat. Sometimes you have to be relegated to your PCP. Do investigate. Maybe go on fibromyalgia boards, with other people and find out. Just say, does anyone know in so-and-so county of so-and-so state? Anyone who's really fibromyalgia literate. It might not be a specialty like overtly, but sometimes you might find someone who specializes in chronic fatigue syndrome to also be proficient in fibromyalgia if that helps. But yeah, some rheumatologists don't give a hoot about FMS because they're like, it's not rheumatological. Well, maybe it's not. They don't really know, So it is really unfortunate. But when they say you have fibromyalgia, go see a shrink, that is so insulting and mean and incorrect. It's just, I hate the word offensive, but it's really offensive. How dare you say that to somebody who's in physical pain? I just, all right. Spine surgery says that my attorney sent that form to print and fill out, also all reports from the doctors. Are they going to file online? They could be taking what you put in your 3441 and then they're going to draft it online. I assume that's what they're going to do. Because unless they don't do a lot of this kind of work, we cannot enjoy direct payment of withheld fee if we don't file everything online. The only exception we get, I presume, because I've had to do this in rare moments, when the system just failed and it wouldn't take, I'm like, I'm sending this in paper version because your online would not accept his appeal. It happens once in a blue moon. And then we do it by paper. But yeah, so they're probably going to do it online is my guess, Spine. And they just need to know your information. And think about it. Most of it is getting the updated medical records. So you have to just put all medical offices that you have seen since you applied. Even if you told the adjudicator about it in between, called them up and said, hey, I got another, put it on the appeal. You don't know what that adjudicator did. And that's really all. That's all information you have. You don't need to watch a video for that part, right? And if you don't know something exact, an exact date, you can ballpark it. If you don't know the date of a test, say, I don't remember the date, or ballpark it, because they're going to order when you have that, they're going to order all those records and those diagnoses are going to show up there anyway. So, it's not really critical to know the exact date as long as they have the range anyway of when you said, you've been treating there for. Last date you were there, all that kind of stuff. So anyway, you're in good hands, I'm sure. We go in. You have to go in where? Why would you have to go in anywhere and submit all next Friday? Are you going to the SSA office or what are you going in for? That's really not necessary, but okay. If they are old school, that might be something they're still doing. I don't know. Okay. If they practice other areas of law where they're so used to making their clients come in and sit in the waiting room and whatever, they might still do that. It's not really how SSD is generally run, but everyone's got their different styles. And sometimes if you come from a traditional, I've been in this field so long, and I was like solo practitioner before that with general practice. I've always done things. I never felt stuck in like a traditional rut mold. But on the same token, maybe they have a reason for this. So I'm not specifically knocking them. I'm just saying it's unusual in the more modern era of getting it done. Not to mention half my people can't travel. I would never have them be required to meet me. 39 Renee. We are over 2 hours. So the judge assist, give me her number. The judge's assistant, right? 39 gives me her number and said I could call her with any question, even though I have a lawyer. Is that okay? I have been waiting since May for a decision on my hearing. Oh, I was thinking about, I don't know if you continued that. No. I think this is our last question, by the way. Oh, that's very sweet, actually. That is very sweet. I mean, is it okay? Yeah, it's probably okay. I don't really want my people calling anybody. I want me to be doing it, but if they have a question that needs an answer, I can just give it to them. So I'm not sure why you would want to call the judge's assistant. It's very sweet, though. She gave you her extension, I guess. That's nice. Maybe, I don't know. If you have a lawyer, why would she be doing that? Don't know. Does she know something you don't know? Just kidding. Okay. Yeah, but it's all good. And it's been May, so June, July. It's only 2 months, Renee. 39 Renee. That's not that long for decision hearing. That's not abnormally long anyway. I know it's frustrating for your end, from your point of view, but it's not the worst thing. So anyway, are we all good, guys? Anybody have a question? Pop it in now or forever hold your peace. At least till next Wednesday. Howdy, anybody? I'm going to go have lunch in a minute. 3:20. Okay. I think we're good. Right, guys? All good. I don't see any questions. But you know how to reach me, and I'll be here next Wednesday at 1 p.m. Eastern Standard Time, so feel free to pop in. If you... I didn't have this. What the heck? No, not that. If you... Yeah, that should have been there the whole time, guys. Or actually, this one I like better. There you go. If you need an eval, you know how to reach me. joydisability.com. And if you look in the... When you're looking at your screen, it'll be to the left. That's the free Social Security Disability Evaluation link. If you just need a consult, because it's not going to be something I represent you on, but you have questions or you want help with a form, it's prepaid, but that link is over to the right. Same page, joydisability.com. Okay? So I appreciate it, guys. Have a great week, and I'll see you next Wednesday. And 12 o'clock, video shares every day during the week. All right. Bye now.